Okay, we are now recording. All right, well, this is a public deliberation, which is scheduled in the case of the citation case of involving the property on Rockaway Boulevard. This is case number 24-019, owned by the Tunneys. We've been through this case a number of times ourselves, or at least Mr. Lauer and I have. And so what the question before us today is whether I don't want to call them victims, but whether the witnesses, I suppose, in the underlying citation case are authorized to appeal the decision of the administrative law judge to the Board of Appeals. And they have made a number of arguments. I don't want to belabor that issue, because frankly, my view is that they don't. I mean, the statutory language is pretty darn clear, and the practical implications of opening up the appellate process to witnesses, interested parties in what the county tells us is approximately 16,000 cases a year, which is a kind of an ungodly number, but even if it's a tenth of that, and if even only 1% of them took an appeal, we'd be talking about a number of cases that would just kind of frankly overwhelm the system. So that's my view. I suspect it's the view of the two of you. Am I correct in that? Is there any real dispute here about whether there can be an appeal taken?
I agree with you completely, Mr. Chairman. We just have to narrowly look at the law and apply it here. And I don't think we can get to the merits of whether the shrubs were part of the original intent or the opinion from the ALJ. I just don't see any leeway here for us. I think the law is pretty clear. I agree with you completely.
Mr. Selma?
Yes, I agree with you. I think that the decision as to who gets to appeal is ultimately a political decision for the county council. They could expand that class if they chose to, and they haven't. And the decision on the part of the county as to whether appeal is also ultimately a matter of policy or politics. And if someone is aggrieved with how the county chooses to do that, there are avenues they can take up to get relief. But I don't think that we can expand that class in what is a code enforcement hearing.
Right. So the one caveat that I guess I want to state for the record is that my own view on these very specific facts might be different if the Rockaway Beach community did not have available to them the special hearing procedure to test these issues. And I say that for two reasons. First of all, the opinion of the ALJ is completely wrong. It is utterly unprincipled. And it defies my understanding as to why the ALJ took the position she took. I went back and re-listened to the tape this week, and there is no lapse of time in between Ms. Bussey asking for some clarification about what shrubs are appropriate and what shrubs are not appropriate, and the ALJ's pre-prepared decision indicating that landscaping was not an issue associated with this property. Okay, now that's just wrong. Okay, I mean, it's just wrong. And all you have to do is look at our opinion. I'm Mr. Lauer, might, notwithstanding Mr. Lauer's well taken. I mean, reasonable minds could differ about how we address the case. In fact, reasonable minds did differ because Mr. Lauer and I differed on the deck. That's all well and good. That's fine. That's just the way life works. I mean, I'm aware of a New York Court of Appeals case where the court decided 4-3 that reasonable minds could not differ about a particular legal proposition. Well, that's amusing, but the opinion specifically addresses landscaping. Okay, it refers to the email from Mr. Rush in 2006, where he quite gracefully chose not to pursue a landscaping alteration that could have the effect of blocking the water view. Okay? That's in 2006. That was communicated to Mr. Weissman. Number one. Number two, there's this discussion about how the word landscaping is not defined, and therefore you have to resort to Webster's to figure out a definition of it. Well, that's wrong on two counts. First of all, landscaping isn't a term in the BCZR, so we don't look to Webster's for words that are not zoning words. It's a real property word. But even if we were to look at Webster's, which I did, the third definition includes any permanent alteration to, the topography or to the land, to the property, which landscaping is. So even, so it's all quite honestly confusing to me. It's as if the ALJ decided to be a some super member of the Board of Appeals and decided she didn't like what's going on here and she was going to put an end to it. Well, ironically, it just rips the scab, the scab that was beginning to the healing that was hopefully
Michael, you still there?
I'm here. I think we lost Mr. Evans.
I think we lost Mr. Evans, yes.
That's not good. He's in charge.
I know. He was in the middle of making his point here. Tammy, can you help us?
It's on Joe's end, so we're going to have to give him a minute
Okay.
to fix this. So I'm going to pause the recording until he can get back in.
Okay.
Okay. Okay. It's
okay. So for some reason the recording ended. But in any event, what I was saying was there have been 4 ALJ hearings. There's been a Board of Appeal, now 2 Board of Appeals hearings. There's going to be most likely another ALJ hearing, another Board of Appeals hearing. Okay. This thing's been going on for 17 years. I mean, if the ALJ had just said, I've looked at these pictures, I've listened to the testimony, I don't think these shrubs block the view. She just made that simple factual finding. I mean, we would have probably affirmed that without without a second thought. I mean, it's a factual finding. It's largely invulnerable from review. We followed the law. And we wouldn't substitute our judgment for hers. Frankly, I didn't even look at those issues. I didn't even look at the pictures, except fleetingly. I don't know whether these shrubs block the view or not, but I know that the notion that landscaping can't be addressed in this ongoing saga is wrong. So that's number one, why I might look at this differently if there was not a special hearing procedure available. And number two is the county. Okay? The county says it doesn't have a policy, yet it has never once since 2016 appealed something like this. Not once. And it didn't disclose that. It was very disingenuous in its communications with the residents there about whether they would appeal or not. They didn't just come out and say, we never do. Right? So there needs to be some transparency there. I mean, really, that's not a straightforward dealing. And the simple fact of the matter is that if the county had appealed this, if the county had bothered to say, okay, here's a matter that's been going on 16 years in this community, okay? 16 years, 17 years in this community, okay? If we've had innumerable zoning hearings about it, there's obviously important, issues here to resolve. Once out of the 16,000 cases this year, we're going to try and put an end to this by taking an appeal. Okay, and then we could have said maybe we wouldn't have agreed that landscaping is part of it. I don't know. We could have hashed that out, but maybe there would have been a factual ruling from the ALJ about whether this particular landscaping impeded the view. So I view the county as, frankly, remiss here, significantly remiss. And, I mean, it's just not, frankly, this thing is just way off the tracks of where it should be. Okay, there should have been a nice, easy ruling about whether or not the shrubs blocked the view, and boom, this case is over. Now we're going to have what, 2 more years of this? Probably. Ms. Bussey took some umbrage at the notion that the Tunneys were the losers here because they're going to incur attorney's fees. Well, maybe Rosenberg Prout views the Tunneys as part of the underserved community and is going to give them free legal services, in which case Rosenberg Prout will be the big loser here. But the simple fact of the matter is, this is a simple neighborhood dispute in Baltimore County, Maryland. Okay, we're not living in Gaza. We're not living in Kyiv. We're not living in Port-au-Prince. Okay, it just has to be resolved. It just has to be settled and done with. People just have to get along here. And frankly, the ball is in the Tunney's court. Just make some overtures, resolve this, let everyone get along. They did fine after the initial problems with the Russians. Everyone got along fine. Everyone can get along fine again. Okay? But the only people that can make that happen, frankly, are the Tunneys. It would behoove them to do that. And that's my sermon. Please, 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 people. Let's get this over. Okay, let's all be adults. Let's not worry about shrubs, huh? Please. So anyway, I'm sorry for that. I know it's not good form to criticize fellow colleagues. But I don't know. It's been done to us. So, you know, turnabout's fair play. Not in this case, but in other cases. We've been chided and criticized for our rulings. So, you know, I don't feel completely bad about it. In fact, I don't feel bad about it at all. But so anyway, our ruling is that this case, that the appeal is dismissed because the witnesses in the case have no standing or no authority, or I'm not even sure what the right word is, but they have no legal basis to note an appeal from an adverse ruling of an ALJ decision, a point which I'm sure the ALJ understood fully well when she issued her opinion. So, unless anyone has anything else to say.
No, Mr. Chairman, just briefly, I agree with you on our ruling, but having lived through a case called Layton versus Howard County, 10 years, neighborhood dispute that went up to the Court of Appeals and then came back down to the zoning board and went back and forth and whatever for 10 years. I understand your plea, if you will, to try to get this resolved. Not that it makes a difference to us, you know.
Right.
We'll
It
have
doesn't
a
really.
hearing or not have a hearing on it. We'll deal with it however we deal with it. But
Right.
it's just, it was just my experience being on the other side of it, if you will, for 10 years for one case. It just makes it very frustrating, very draining on everybody. And at the end of the day, was it all worth it or not?
Right.
You
Right.
know, the frustration, not just only the money, but just the emotional stress and daily kind of grind on you
Right.
that I experienced from afar. I was a lawyer in the case, so I was,
Right.
you know, they're hands-on in the neighborhood every day. But I understand completely what you're saying, and I agree with your analysis regarding the case itself and our way. I don't see any other way for us to proceed.
No, and I've been involved in two cases as an individual, two zoning matters that were protracted. One of which I was the actual neighbor. Okay, I was the actual neighbor involved in the fight with the other neighbor, and that went all over the place, including to the Court of Special Appeals.
Yeah.
And it's a miserable way of living. It's a miserable overlay on your life in your neighborhood when you drive home at night and see are reminded of the contention.
Yeah.
And another case, I was a community person in a case that went up to the Court of Special Appeals, I think, maybe the Court of Appeals, I forget now. And, you know, it's just unpleasant. It's just unpleasant. And you know, it just doesn't need to be. I mean, there are important issues that need to get resolved sometimes. And, you know, we do our best to do that. And as I say, you know, look, the decision in this case was 2-1. I get it. I understand the dissent, and the dissent obviously understands the majority. It's that's, you know, reasonable minds differ about things. That's all well and good. That's fine. But enough is enough at some point. So anyway, anyone have anything else to contribute to the good of the cause here? No. Okay. All right. Well, then we will adjourn, and we will issue a ruling forthwith. It won't be long. Okay. It'll just, you know, basically say that, you know, that the appeal is dismissed because the appellants don't have the authority to note the appeal. Okay, I don't see any
Okay.
reason for some lengthy diatribe here. And we'll just, do that. Okay.
Okay, thank you, Mr. Chairman.
Okay. All right. I'm gonna take us off the recording now.